Welcome to You, Me, and IP. Hi, Dominic. How are you today?
Yeah, good. How are you, Sharon?
I'm good, thank you. So I'm at Greenspoon Marder. We are a national firm and we have an IP practice that has attorneys across the United States. We have about 15 lawyers and we mainly do trademark and copyright, litigation, prosecution, and some patent litigation as well. Also trade secrets, of course. And Dominic, you are from Shoosmiths.
Yeah, we're a trademark attorney firm that span the whole of the UK. We have about 1,300 lawyers and about 1,700 practitioners in all. So we cover the broad range of IP and also other law as well.
Well, thank you for joining me today. I think we're going to have a lot of fun talking about the similarities and differences between the United States and the UK with respect to trademark law. Um, what is required to get a trademark under the law of the United Kingdom?
So in the UK, when you submit your application, all you need to give them is a graphic representation of the trademark, the goods and services claimed, and the owner. The owner has to be a real person or a real legal entity. It can't be, you can have partnerships, but it's more detailed if you have partnerships. It has to be a real legal entity, a clear legal entity. It can't be a trading body, things like that.
In the United States, in order to get a trademark, you have to prove that you're using it or you have to file it as an intent to use application. Is it the same way in the UK?
It's similar. So when you file your application in the UK, there's a tick box which says bona fide intention to use. And that means you have a genuine legal intention to use the trademark within 5 or 10 years. And what you have is for the first 5 years, you can assert your trademark, and that's not contestable by anyone else if you assert it, whether you've used it or not. So you can assert it against anybody in opposition or in infringement proceedings for 5 years. But after 5 years, if you haven't used it, they can ask you for proof of use, either in opposition or infringement proceedings, and say, prove use. And if you haven't proved use, you can't assert the parts you haven't used it for, or the goods and services you haven't used it for.
Wow. So can you, in that first 5 years, let's say you file an application and you haven't actually used the trademark, can you sue someone else to stop them from using it during that
Yeah,
5 year period?
you can do, yeah. And this period's to allow you to get your business up and running. It's 5 years to get your business up and running, in which case you've got a bit clear space of 5 years. And then after 5 years, you have to defend your mark by using it.
So what happens if you sue someone to stop them from using it in that first 5 year period, and then for whatever reason, you never end up actually using it?
Then they can then use it after that. They can revoke your trade after the 5 years. So after 5 years and one day, they can apply to revoke your trademark and then file their own trademark application themselves.
That it's so different than the United States. Our rights accrue from use, as I think you know. And before we file trademark applications, we have to conduct a pretty exhaustive search to clear the mark. We call it a clearance search to make sure that nobody else is using it. And if we file it and we are not using it, then it needs to be done as an intent to use. And we have 6 months, only 6 months in which to file our statement of use. So that's very
Yeah.
different.
But you can extend your 6 months, can't you?
You
If,
can.
yeah, for a few times. So you do get a bit of time to get up and running. What's the maximum you can extend the 6 months to?
Well, typically you can extend it twice, 6 month periods, but at a certain point, the USPTO is not going to continue letting you extend it, but you certainly do not have 5 years in which to use it. The statement of goods and services, we have to give a pretty detailed statement in the United States identifying the exact goods or services that the mark is either being used for or will be used for. So if, for example, the client is filing in class 25 for clothing, they can't file and identify hats and socks if they're only selling it for t-shirts. Does it
Yeah.
require that level of detail in the UK?
It didn't do. So in the good old days when I first qualified and when dinosaurs walked the earth, you could claim you tick your tick box for bona fide intention to use and you claim whatever you wanted. And you wouldn't really get questioned unless it became an issue of non-use revocation later on. It would never be questioned. But now there's a new Sky Kick versus Sky case where Sky, and this is in the court of the Supreme Court that was the latest decision. So Sky actually filed lots of trademarks, as businesses do, and they claimed a wide range of goods. And they actually claimed things like bleaching preparations in class 3. And this is Sky, who do TV, television programs and television broadcasting.
Did you say
So they,
bleaching preparations?
yeah, in class
What's a
3, and
bleaching
whips in
preparation?
class 18. And this was it detailed in the case as well. And they said, look, you've got obviously no intention of using these. You obviously you've filed broadly, which people do, but in doing so, it's obvious you have no intention to use these goods. So therefore, they actually ruled that they were filed in bad faith. Certain goods were filed in bad faith, and they actually took them off the register for those filings. But then there was another lot of the same decision said there was another category of bad faith where you don't intend to offer across the whole range of goods because they filed computer software, which is really broad. That includes computer software that does business, does works computers, does whatever, navigates cars. It's a really wide category. And they said that's so wide, you can't possibly use it across that whole category. Even Sky can't do that. And so they said, again, this is bad faith.
And so if there's a finding of bad faith, can that lead to damages? Or does that only happen if there's an opposing party?
Yeah, so in this case, they narrowed their goods down, and then because it was also an infringement case, it said, do Sky Kick still infringe your narrower goods? And it turned out in services, it turned out they still did anyway. So they won the case for infringement because even with the narrower goods and services, they still infringed.
Well, it's interesting. In the United States, we can have court proceedings or we can have proceedings in the Trademark Trial and Appeal Board. And you cannot get damages in the Trademark Trial and Appeal Board through, the USPTO. You can only get damages in court. And if there is a finding of bad faith, which is not made in the TTAB, that would be made in the court, it can lead to enhanced damages. It
Yeah.
can also lead to an award of attorney's fees, qualifying as an exceptional case under the Lanham Act. But bad faith in the trademark office, that really doesn't get you anything other than perhaps a cancellation if there's a fraud on the USPTO.
Yeah, with our proceedings in front of the register, you do get a cost award, but the cost award is very small. It's about the 10th of the amount you get in court, or a 20th. It's really small. And bad faith does increase the cost award, but again, it's so small. The reason you claim bad faith is to remove someone's goods and services, really. That's the real aim of claiming it, or to remove their whole registration, which you can do. If they file in bad faith, you can remove the whole thing.
And are there concurrent use proceedings in the UK so that more than one, individual or entity can own the same mark, but perhaps in different geographic locations or different goods and services?
Yes, there's two ways to argue that. One is to say there's no confusion because you're working in different territories and therefore your end users aren't the same, your customers aren't the same, so they wouldn't be confused. So that's one good argument. Or the goods and services are different. But the other argument, which doesn't happen very often, there's Budvar versus Budweiser, and they both sold Budweiser beer for 20 years in the UK. The branding was completely different, and they sold them happily side by side for about 20 years. And the UK public weren't confused. Then they both filed trademarks, both cross-opposed. And the court said, actually, because you've been trading for so long and there's no confusion, you have concurrent use and you're happily coexisting. So you can't oppose each other, but you can keep your own marks, which
Right.
I
And
think is fair.
the point is to protect the consuming public from
Yeah.
confusion. So, we have Delta Airlines and Delta Faucets. There's no way you would confuse those two. Um,
Yeah.
it's, but it's that's how I describe the Lanham Act, is it's really intended as a consumer protection statute in a lot of ways, because the whole point is not just to protect people's intellectual property, but to protect the public that associates certain brands with certain product or goods or services.
Yeah, you're right. We have polo cars, polo suites, polo t-shirts, all different kinds. They're all owned by different owners. You're right. And there's no confusion. So they happily coexist.
And so one thing you and I were talking about the other day was descriptive marks. And that's always the toughest kind of mark to deal with in either the USPTO or in a court proceeding, because, you know, companies like to have descriptive marks because they want to tell the public about what their good or their service is. But we as trademark lawyers, we don't like descriptive marks because unless they have secondary meaning, they don't have protection.
Yeah.
Is it the same way in the UK?
Yeah, definitely the same in the UK. Yeah. We had one vodka case for a well-known vodka, and it was ruled descriptive in Canada already. There was a judgment where it said in Canada, this is descriptive in Canada. So that was certain judgment. And then there was other countries where they suggested it was descriptive, but it wasn't a ruling that it was descriptive. And so we filed an application for the vodka in the UK, and it was opposed, and the evidence was 600 pages long with all these dictionaries saying this vodka means this, which is a descriptive use. But we're able to combat that with a survey where people actually recognize the vodka and said this is the vodka by name and it's made by these people. And because of that, we won the case. So that's a quite distinctiveness. So you can get descriptive marks, but it's hard to get them, and you need evidence of use through acquired distinctiveness.
And we were talking about Stanford Stone the other day.
Yeah, that was one of our cases. Yeah, that was for a mark for stone, which is made in Stanford. Stanford's a town which was recognized for stone. Again, we filed the application for our client and warned them that it may be attacked. It was attacked by another party who said it's descriptive. Again, they submitted lots of evidence saying, here's a book which says Stanford Stone and used it descriptively in a sentence, like I build with Stanford Stone, which is descriptive. But then we were able to get loads of evidence. Our client actually used their stone for the royal family and on royal buildings, and we got all the evidence, submitted to UK IPO, which is all public, and we won the case hands down.
Yeah, we have a concept in the US called geographically misdescriptive. So if you called your mark Stanford Stone, but it was actually from Windsor, I don't know where Windsor is in relation to
Yeah.
Stanford, but it would be considered geographically misdescriptive, and the USPTO would not allow it.
Yeah, we have the same. It's called deceptive. They call it deceptive. So we have exactly the same thing. Yeah. Yeah,
And
I agree.
we have some very famous descriptive marks. American Airlines is one. I mean, that's clearly descriptive. Can it get more descriptive than that? But everybody knows exactly what that mark refers to.
Yeah, and it's got acquired distinctiveness through use, hasn't it?
Yes.
Yeah, exactly. Yeah, we're the same.
I would even say that that's a famous mark. So
Yeah.
any other airline that wants to use American, I mean, good luck to you.
No, I agree completely. No, I agree.
And so with respect to another thing we were talking about the other day, which I found really interesting, is in the US, we don't have designations as trademark attorneys or litigators. We're just attorneys. Unless you do something very specialized like file patents, then you need to be a member of the patent bar in the United States. But otherwise, any lawyer can choose to file a trademark application. Let's assume that that person has the requisite knowledge to do so, but it's different in the UK.
Yeah. So in the UK, we used to do exactly your system, exactly the same thing. So in the UK, it used to be that all lawyers filed trademarks and that was it. But then they did an investigation and said, well, actually, it's getting so specialized now and so complex. We need a certain qualification just for filing trademarks, just like you have for patents. So we always had patent attorneys from the 1800s or whenever. So they said, right, let's introduce trademark attorneys. So that's a certain qualification for just trademark attorneys. Like I've got a PhD in genetics, but I never did a law degree. I retrained, did 3 years of exams as trademark attorney, and qualified as a trademark attorney over 3 years through exams and practice. So yeah, you can qualify as a trademark attorney without having a law degree at all. But conversely, you can still be a lawyer and file trademarks. You just can't call yourself a trademark attorney. And you have to have the right experience, of course.
Are you also a patent attorney?
No, I could do both. I thought about doing both, but I did trademarks first, and I found trademarks so much more interesting. I didn't bother doing patents. I just like trademarks. It's more because you have so many different factors. There's usually about 100 factors for each case to consider. The goods and services, the marks, confusion, reputation, everything. It's just more interesting to me than patents.
Oh, I agree. I think it's a very fun area to practice, and it's very
Yeah.
interesting. working with clients and figuring out what strategy they're going to use for their brand to make it as strong and protectable as possible. Those are really fun types of cases.
And it's so subjective. Like me and you can argue a case for months and still never agree because it's just subjective, isn't it?
That's absolutely right.
Yeah.
Well, Dominic, this has been really fun. Thank you for joining me today. And I look forward to the next time that we get to talk about trademarks.
Yeah. Brilliant talking to you. Have a good day.
You too. Thank you.